Hello everyone, my name is Noashira binti Tariq from class BA2732E. My metric number is 20244289888. In this video, I'll be shedding light on an important issue that often goes unnoticed. It is the challenge faced by pregnant women when applying for jobs. Let's explore this topic together and understand what is matter. Every woman has a natural instinct to start a family and raise her own offspring. This experience of being pregnant and giving birth is precious gift. It is the dream for most women. However, at the same time, women also have aspirations and personal dreams, especially in their careers. Thus, modern women emerge who can balance their responsibility as mother and wife while achieving success in the professional world. However, a common obstacle faced by women is the difficult in finding a job that suits their interests and qualification, especially when they are pregnant or planning to have a children. In some situations, women are forced to accept jobs outside their chosen field simply to earn an income to make ends meet. The prejudiced attitude for some employers towards hiring pregnant women adds this to the stress and challenge in the life of women, especially mothers. Therefore, my analysis of this issue is to find what is the challenge are faced by pregnant women and applying for a job, also the impact from this issue, and what are the solutions that we can do. Among the challenges that prevent pregnant women from getting a job is the culture of gender discrimination that still exists in the employee selection process in Malaysia. This is because hiring often in favor of men. Data from World Bank in 2024 show that the labor force participant rate among men is 78.4%, while for women is only 51.6%. This statistic clearly show that the imbalance in women participant in labor market, which is partly due to discrimination against women, especially those who are pregnant or planning to have a family. Discrimination may be direct or indirect. Direct discrimination happens when someone is treated unfairly due to variety of reasons and suffer a disadvantage because of such unfair treatment. Meanwhile, indirect discrimination occurs when there are an unreasonable rule or policy that is the same for everyone but has an unfair effect on people who share a particular attribute. This is because due to women's natural biology structure and family issues such as pregnancy and childbirth, women face discrimination. More than 20% of women have been rejected by employers because they were pregnant during an interview. Furthermore, increasing maternity leave from 60 days to 98 days has become a challenge for pregnant women to find work. According to the Employment Act 1955, Amendment 2022, the maternity leave period for pregnant women has been extended to 98 days. This amendment applies to female employees in the public and private sector, in line with the International Labour Organization (ILO) convention, which stipulate that the minimum period of maternity leave is 14 weeks or 98 days. Maternity leave is an absolute right for every female employee and it's provided with full pay and allowance. Employers who fail to comply with this provision may be subject to legal action as an effort to protect the welfare of women in the world of work and ensure fairness and balance in the right of employees. This situation has caused many employers to be reluctant to hire women, especially pregnant women, as employees. This is because they are not willing to bear the additional cost of providing paid leave, maternity allowance, and having to find temporary replacement. The statement by Member of Parliament support this situation, Datuk Seri Dr. Wee Ka Siong, who stated that employers are reluctant to hire pregnant women because they are worried that it could affect the stability of the company. This statement illustrates the reality of discrimination but still exists against women in the world of work today. The major challenge for pregnant women is the lack of comprehensive anti-discrimination laws, specifically addressing gender and pregnancy in employment. While Article 8(2) of the Malaysian Federal Constitution prohibits gender discrimination, there are no specific statutory mechanisms to enforce this right effectively. In the private sector, the least legal vacuum leads to inconsistent judicial outcome and weak enforcement. The following are examples of cases that show that law enforcement is not comprehensive to all sectors in Malaysia. Beatrice Fernandez as a flight stewardess, a collective agreement that government her terms and conditions of service require all stewardess to resign upon becoming pregnant. The respondent should have the right to terminate her service in the event that she refused to resign. The appellant refused to resign when she became pregnant and was terminated by respondent. The appellant then applied to the court on the ground of wrongful dismissal, submitting that the provision of the collective agreement were gender discrimination. in nature and therefore contravened Article 8 of the Federal Constitution, rendering the collective agreement void. However, she lost the case. The following is an example of case comparison. Nofadila was pregnant and in search of a job. She applied at the local education office in Malaysia to be untrained relief teacher and was elected to receive an offer. After accepting the offer, she duly attended a preliminary briefing and was assigned a position at a local school. Before leaving, she was asked whether she was pregnant, which is she answered yes. To her surprise, the employment was revoked on the spot. Apparently, the education office does not hire pregnant women as release teacher. The court in this case decide the discrimination on the basis of pregnancy is a form of gender discrimination and thus she won her case and entitled for an amount of damage. The two cases show that there are different decisions given by the court cases of gender discrimination. The results are not the same where the rights of working mother in the private sector are not protecting and result in termination of service due to pregnancy, while in the public sector the rights of working mother are protected by law. Therefore, the law governing discrimination must be consistent regardless of whether it's related to the public or private sector, because pregnancy is a natural state for women and punishing them for being pregnant is unjust and inhuman. Next part, we move to the impact section. The impact based on employee, organization, and government. Firstly, based on employee, pregnant women face significant disadvantage during job application due to systematic discrimination and the absence of specific protective law. Employees have rejected more than 20% of women because they were pregnant during an interview. This reality creates stress, insecurity, and discouragement among job-seeking women, limiting their ability to participate equally in the workforce. However, on the positive side, such challenge has triggered growing awareness and advocacy. The stresses that visibility of this issue encourage public discourse on equality and push for inclusive policy reform that could benefit women in the long term. The negative impact based on organization is pregnancy discrimination during hiring present both ethical and operational risks. Negatively, such practice can lead to a narrow talent pool, public backlash, and even further regulatory penalties as policy evolves. The study emphasized that workplace discrimination not only undermines morale but also hampers innovation and employee retention. On a positive note, companies that adopt inclusive hiring practice and support pregnant candidates can foster loyalty, boost employee satisfaction, and enhance their brand image. These organizations are more likely to attract top talent and create a supportive culture, aligning with the study finding and inclusivity drive organizations' success. Lastly, the negative impact from the government perspective, the lack of explicit legal protection from pregnant women applicants reflect a critical gap in labor law. In the Malaysian Journal of Sharia and Law argues that Malaysian legislation, particularly the Employment Act 1955, does not cover pre-employment discrimination, leaving pregnant women unprotected when seeking job. This omission can undermine Malaysia's reputation in adhering to international human rights standards, such as CEDAW. However, this gap also offers the government an opportunity to strengthen its legal framework. The other recommended that Malaysia adopt global best practice, which will not only protect women but also elevate the country's compliance with international labor norms. Next, we move to the part of the solution. It is to address the issue discrimination against pregnant women through an international agreement adopted by UN General Assembly in 1979 and Malaysia accepted in 1995. The CEDAW Agreement or Convention of the Elimination of All Forms of Discrimination Against Women. CEDAW is a legally binding agreement that defines standards for equality between men and women. The following are the rights or measures to eliminate discrimination against women in the field of employment to ensure the fundamental equality of men and women have the same right. The following are the right or measure to eliminate discrimination against women in the field of employment to ensure the fundamental equality of men and women have the same right. Firstly, the right of work as inalienable right of all human beings. Secondly, the right to the same employment opportunity, including the application of the same criteria for selection in matters of employment. Thirdly, the right to free choice of profession and employment, the right to promotion, job security, and all benefit and condition of service, and the right to receive vocational training and retaining, including apprenticeship, advanced vocational training, and recurrent training. Next is the right to equal remuneration, including benefit, and to equal treatment in the respect of work of equal value, as well as equality of treatment in the evaluation of the equality of work. Last but not least, the right to social security, particularly in case of retirement, unemployment, sickness, invalidity, and old age, and other incapacity to work, as well as the right to paid leave. And lastly, the right to protection of health and to safety in working conditions, including the safeguarding of the function of reproduction. The same cases I take from Nur Fadilah Ahmad Saikin attended an interview to become a teacher during the instruction meeting, and she was asked to attend, and she revealed that she was pregnant. Her offer letter was withdrawn. The High Court ruled that the action was a form of discrimination based on sex and violated Article 8(2) of the Federal Constitution, which prohibits discrimination is appointment to public office. The article of the Federal Constitution was adopted to comply with Malaysian obligation under Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW. In conclusion, this discrimination faced by pregnant women during job application remains a serious barrier to gender equality in Malaysia. This is to stem from outdated employer attitude, the financial burden perceived from maternity leave, and significant gaps in the anti-discrimination legislation. The negative consequences affect not only employees but also organizational performance and Malaysia international standing. However, with the implementation of dividend-based solutions such as aligning law with CEDAW and promoting inclusive promote practice, Malaysia can improve employee well-being, foster equitable hiring, and uphold global human rights commitments. Addressing this issue is essential for building a fair, progressive, and productive society.